Hi, I'm Phillip Jauregui. This is Supreme Thoughts. This is a podcast, a work of Judicial Action Group Foundation. And today we're going to talk about the topic of future Supreme Court vacancies. We don't have a vacancy right now, but I'm thinking back to 2017 and 2018. Of course, there was a vacancy in June of 2018, and that was Justice Anthony Kennedy. And no one publicly knew it at the time, but there were already discussions occurring back in apparently November of 2017 between Justice Kennedy and the White House counsel's office and President Trump's office about a vacancy. And so we're in a similar window now. It's January of 2026. We don't have any reports or news or really indications that there will be a retirement in June. But the absence of that information doesn't mean there couldn't be things happening in the background. The two justices that are the oldest on the court are the two that I think are the best, honestly, and I think a lot of conservatives and constitutionalists would agree. Justice Clarence Thomas and Justice Samuel Alito. I don't want them to retire, but what I really want is for them to follow whatever the Lord has for them. That may mean they both serve another 10 years or if the Lord's will were for them to retire sooner, that would be a difficult thing. But I trust God on that. And our prayer has been not that they stay or retire, but that they follow God and that they don't follow arguments of people, even friends who may be well-meaning friends. But I think it's good for us to be prepared for a vacancy and to be thinking about it. I think there's a chance we could have one. Let's just say that. The Lord knows. We've been preparing for this for quite a while because we've seen how big these are. You know, a president serves for 4 years or 8. Justices can serve for a near lifetime. The Constitution says that they serve, quote, during good behavior, but practically speaking, that means they stay on the court unless they do something horrible and they're impeached, then they stay on the court until they either pass away or choose to retire. That can be 30 years. So this is important. The court right now, there's a tenuous balance. If we lost either Thomas or Alito and replaced them with someone who were a Republican nominee but weren't proven and they ended up being a moderate constitutionally, then we would lose tremendous ground at the Supreme Court and we might end up losing the court back to the left again. We're in danger of that. I don't think it's going to happen because of the work that we're doing and what I'm going to share with you and what allies and other people are doing. But this won't just happen on its own. We have work to do. So I do want to share with you today research that we've done on a prospect, and I want to tell you about that process. Many of you know that I've been working with Judicial Action Group for over 20 years now. This year, we formed a foundation, a 501c3 foundation that also does research. And of course, I'll share research and education with you today. We're not lobbying. There's not a vacancy, but we do want to talk about the research out there. So I've been doing this for 20 years. And for the last 3 to 4 years, I've also been working with the American Family Association Action out of Mississippi. They have radio stations all over the United States, about 200 radio stations. The Wildman family, Tim and Walker, understand the importance of this topic of judges. So they've asked me to found and work with them on their project. And so Judicial Action Group and American Family Association have a research cooperative. We do a ton of research and share that research with each other, but then we also share it with tons of outside groups that care deeply about the topic of judicial nominations, but they may be covering 20 to 30 topics all at once. They may have a much bigger budget even than I do, but they don't necessarily work on judicial nominations. So this is a fairly thin but very deep silo that has a great impact. And I want to give credit to American Family Association because we couldn't do this project. I couldn't do this project at JAG without the partnership and the cooperative that we have with them. As we've engaged in this research project, we've researched now 30 to 35 different prospects for the Supreme Court. And we've looked at a number of different topics, everything from judicial philosophy to the prospect's worldview, which is incredibly important, their faith even. We've looked at what their view is and what positions they've taken on life, religious liberty, free exercise of religion, LGBT issues, Second Amendment, COVID craziness, all these other topics, which is really important. But there's also a standard that we've used, and I want to read that to you and explain it because it's really important as we're evaluating these prospects. We're looking for the best long-term, or the prospect with the best long-term demonstrable record of commitment to the constitutional role of judges, which is to decide cases according to the original meaning of the Constitution and statutes and to never legislate from the bench. Now, let me explain that a little bit. We're looking for the best. Some people might say, well, here's a prospect and they look really good. That might be true. But when it comes to the Supreme Court, good is not good enough. We're looking for the best because we're likely going to have one vacancy at a time. And so we don't need to find somebody that's a risky name or that doesn't have a proven record, but certain people are endorsing them. Our point would be, let's find the best and let's base it on research and data. The second point we have in the standard is we're looking for the best person with a long-term record. We're not just looking for someone who gave a speech a year ago that detailed the correct positions on every topic that we're researching. That's good if someone did that, but it's better evidence to say someone not only gave a speech last year, but they gave that same speech 20 years ago, and they've given it every 3 or 4 years since then. I'm using the speech as an example, but really taking those positions. So we're looking for evidence. Long-term is better than short-term. Wouldn't you agree? And then finding evidence throughout a number of different areas. As an attorney, maybe they've been a judge, maybe they've written law review articles, maybe they've spoken at different legal meetings, right? But someone also who has a demonstrable record. It's not good enough for me or anyone else or a leader to say, this person, Susie Q, would be a home run for the Supreme Court. If you really value my opinion, you might think, I appreciate Phillip. I agree with him. I admire what he does, or I tend to agree with his constitutional philosophy. So if Phillip says Susie Q is great, I'm just going to take that position as well. It's okay to listen to people that you respect, but I want to ask all of us to look for a demonstrable record. What I'm going to give you today might even bore you a bit. We're going to give you a document. We're going to go through a lot of detail on one of these prospects, but this is a demonstrable record that I'll share with you rather than just a mere endorsement. So when you hear other people endorsing someone, that's fine, but ask them for the data. Ask them for the demonstrable record, like a document, like I'm going to share with you. That's what you need. You need footnotes. You need information that you can go check. We do that when we have a congressional race. We do that when we have a presidential election. How much more a Supreme Court justice that'll be on the bench for 30 years? Okay. It's not enough to just have somebody say they think they're great. And then finally, the standard is we're looking for someone with a demonstrable record of commitment to the constitutional role of judging or of the judiciary, which is to decide cases, is what Article 3 of the Constitution says. The role of judges is to decide cases, and to do that based on the original meaning of the Constitution and legislative text, and to never legislate from the bench. So like I said, we've researched between 30 and 35, I think it's approaching 35 now, prospects for the Supreme Court. We've done this over the last 3 to 4 years. Been a lot of work, but it's worth it because of how important it is. And I want to share with you some of the research that we have on one of the prospects that we've put on our green list. Right now, we have a green list that has 4 prospects on it. Green, meaning go. These are people that we think would be good or great for the Supreme Court. In other times, I'll share a red list that we have. We've also created a red list because there are other folks that are out there who have talked about other prospects for the court. These names may have been promoted in news articles, and because they have the potential to gain traction, we thought it's necessary to also write up reports of our research and concerns on those prospects. Keep in mind on those red listers, we're not trying to be mean. We're not trying to go negative. What we're trying to do is to say, yes, there is some positive evidence or some positive points in favor of this prospect. That's true. But there are also some pretty major concerns. And when you compare that to the people who were on the green list, why would we pick a prospect that has some good points? They're a nice person, perhaps, but they're a lot riskier than one of the green list prospects that we have. You know, Republicans over the last 50 years with Supreme Court nominations, we've gotten it wrong about half the time. That doesn't need to happen in the future. And one way that we keep that from happening is by finding prospects with the absolute best record. So that's, again, why we have some red list prospects, and I'll be covering those in the weeks ahead as well. So let me tell you about one that we like, that we think would be great for the Supreme Court. And by the way, if you don't like my list, you can come up with your own. I think that would be good. I think it's good to have a debate. These are great prospects, but I'm just saying if you don't fully agree, I think it would be good for other groups too to be coming up with a green list and a red list, or however you want to phrase that. The Honorable Judge Kyle Duncan is a judge on the U.S. Court of Appeals for the Fifth Circuit. He's one of our green list prospects, and I want to tell you about Judge Duncan. He's 53 years old. Again, like I said, he's been on the Fifth Circuit now since 2018. President Trump nominated him to the Fifth Circuit, and he was confirmed. I won't read all of his past work history. You can pull this research report, from the Judicial Action Group website, the JAG, which is at jagf.org. Judicial Action Group Foundation is jagf.org. You can pull this research report. So one of the prospects that I want to talk with you about today is Judge Kyle Duncan. He's on the U.S. Court of Appeals for the Fifth Circuit. He's been there since 2018. He was nominated by President Trump. And you can pull this report, by the way, at the JAGF website. That's jagf.org. You'll be able to find these reports. This is a 11-page report summary. It has a number of footnotes. Gosh, yeah, a lot of footnotes in here, so it's well documented. We try to write it in a way that non-attorneys would enjoy and understand and be able to digest, but also with enough research and citations that it's a great research document that's going to be beneficial to everybody. Again, Judge Duncan's been on the Fifth Circuit since 2018. He was general counsel with the Becket Fund for Religious Liberty from 2012 to 2014. Again, we're looking for someone with a long-term record, and the fact that Judge Duncan, before he was a judge, was at the Becket Fund, a great constitutionalist legal organization defending religious liberty. He was there back as early as 2012. So again, he has a long-term record. And as you'll see too from the research, we have evidence even dating back prior to that. But that's very helpful to know that he's been a part of the cause and part of constitutionalism, defending religious liberty back that far. He also was a law clerk for the U.S. Court of Appeals. Let me tell you now about some of the things in Judge Duncan's record, and I'm going to give you a lot of the quotes straight from Judge Duncan, because it's one thing, again, if I'm telling you something about him, but we want to give you quotations, give you original source information so that you can hear what he has said, what he's written, okay? So this is on the topic of judicial philosophy, which is the entry point on a judge. Everything that we want to know starts from their judicial philosophy. What do they believe about the role of judging? He said, if improperly exercised, again, if improperly exercised, the judicial power distorts the balance of governmental authority in favor of our least accountable officials. That was in 2008, dating back quite a ways, so 18 years ago, right? And again, you can pull this research report. I'm not going to cover everything in it because you can read all of it, but I'm just going to hit some highlights. This is on another topic, the topic of faith and the public square. Judge Duncan is a devout Catholic. He's a Catholic Christian. I would make that distinction that he is a Catholic Christian, because I would say within different Christian denominations, there may be someone who attends a Baptist church, but they may not be a Christian. They may not know the Lord. Someone may attend a non-denominational church, but they don't know the Lord. And so I make that distinction that he's not just Catholic. He is a Catholic Christian, a believer, and has a relationship with the Lord Jesus Christ. That's essential. He was speaking of, he has been a critic of the modern understanding of the Establishment Clause. and said that he described that the basic problem seems to be this. Speaking about the Establishment Clause, he says, here's the problem, quote, the circle of government actions forbidden by the Establishment Clause has been drawn too vaguely and too broadly around something perhaps described as bad relationships between government and religion. The circle needs to be far tighter, drawn in terms of establishment as a legal construct and less as a cultural, sociological, or theological construct. Drawn in terms that restrain distinct institutional relationships between the state and actual churches, instead of policing the vague boundaries between the religious and the secular. In other words, what Judge Duncan was saying back in 2008 before he was a judge was that the Establishment Clause really needs to be read and applied as a legal construct, not a sociological one. We need to stick with the legal language. And what is an establishment legally? That's the question we need to be looking at, and not just trying to police any relationship between government and God, or government and religion, or government and Christianity. On the topic of religious liberty, Judge Duncan said he served as lead counsel in the Hobby Lobby case. Many are familiar with that case, and he represented Hobby Lobby in seeking a preliminary injunction against the enforcement of a federal mandate requiring that it provide insurance to its employees for all FDA-approved contraceptive methods. He also represented the Nuns and the Little Sisters of the Poor versus Sevilla, battling the same federal mandate. His advocacy for religious liberty has taken place in and out of the courtroom, in and out of judging. On another topic, the sanctity of life, Duncan has supported unborn life both as an attorney and as a federal judge in a number of different contexts over the years. In 2013, he worked with the Becket Fund, which is where he was working, of course, at the time, and he was there to, quote, defend the conscience of millions of Americans impacted by the government abortion drug mandate imposed under the Obama administration. 2 years later, in 2015, when he was in private practice, Duncan represented the state of Louisiana in a lawsuit and was defending its law, which was requiring abortionists to have local hospital admitting privileges. Again, took a pro-life position representing the state of Louisiana. 2 years later, Duncan co-authored an amicus brief supporting Texas's abortion restrictions in the Whole Woman's Health versus Hellerstedt case. He also defended a Texas law requiring clinics. He defended a Texas law that required clinics that perform more than 300 abortions per year to register with the state. There are many other items that I could cite here on that topic of the sanctity of life. Another one that I do want to mention though, and in another topic area, LGBT issues, back in 2015, Duncan represented the birth mother of 3 children who wished to prevent her former same-sex spouse from obtaining visitation. In other words, you had the biological mother with 3 children. She had been, quote, married to a woman, a lesbian woman. This mother was no longer a lesbian and didn't want the children to visit with the person that was not their mother. They only have one mother biologically. And so Judge Duncan, then before he was a judge back in 2015, defended that woman in that case. Also in 2017, he represented a Virginia school board and a challenge by a transgender student over bathroom access. This is back in 2017. I'll pause here briefly because I think we've seen the tide shift back on the whole transgender issue, which is a good thing with President Trump coming in. Things have shifted, but a lot of people were caving to the trans agenda just as they were caving to the homosexuality agenda and every other sexual immorality agenda over the last few decades. It was just the next step. And you saw a lot of people caving on that topic, including Republicans even. And the fact that Judge Duncan, before he was a judge, stood against it is really important. And we'll contrast that with maybe some red listers that haven't stood strong on that topic. And it's one way to distinguish between those that are the best and have courage and those that perhaps aren't. That's an important thing to look at. But in that case, dealing with the transgender student wanting bathroom access, Duncan described the school's rule requiring students to use the bathroom aligning with their biological sex as a, quote, common sense restroom and locker room policy. And he asserted the position that, quote, decisions about bathroom use should be left to the states and local school boards rather than liberal federal mandates at the time. Judge Duncan also opposed the decision in Obergefell, the 2015 activist decision seeking to destroy marriage and make it homosexual marriage or mandate that for all of the states. He wrote the day after that decision was issued. I won't go through all of the quote, but you can find that again in the research that Judge Duncan opposed that decision back in 2015. He also represented at least 15 states who sought to defend their marriage laws prior to Obergefell. So again, this was now 10 and more years back. He was defending over 15 states who were defending traditional marriage laws. In 2010, when he was with the Louisiana Attorney General's office, he was lead attorney in a case in which two out-of-state men sued to have their names both placed on a birth certificate of a Louisiana-born child that they had legally adopted together in New York. So again, he was lead attorney in a case in which two men were seeking that, and he defended the statute that prohibited the adoption of the children by unmarried couples. And in another case, in an appeal to the Fifth Circuit, Judge Duncan refused to utilize the preferred feminine pronouns of a biological male litigant. Judge Duncan wrote that Congress has said nothing to prohibit courts from referring to litigants according to their biological sex, rather than according to their subjective gender identity. So again, Judge Duncan in 2020 refused to cave on the transgender pronoun issue. And there are other judges that have been promoted for the Supreme Court, or at least one that I'm thinking of in particular, that took the wrong position on the use of pronouns. And so again, these are the issues that are very important. They're not just marginal. They're not just at the margin. They're at the core, I believe. And they go to showing courage. And it's one of the reasons that we really like Judge Duncan. Judge Duncan is because of the evidences of courage that we see throughout his record in taking difficult positions when it wasn't easy. Looking at his faith and worldview, he was out of the Catholic Church for about 20 years. He has described his own journey, and he returned to it around 2006. He does have a robust faith, and he speaks openly about it and seems to actively submit his work to the Lord. And listen to this quote from 2012. Again, this is going back now 14 years. He said, he's describing an experience that he had, and he said, "It was the Lord speaking to me." And let me just pause there. I love it. I love it when I hear somebody talk about the Lord speaking to them, because out in culture generally, when we say that, we get criticized right away as Christians. Jesus said, "My sheep hear my voice." This is a traditional Christian tenet of faith, that the sheep of Jesus hear his voice. So when we say we pray and I heard God say, or I'm listening to God, people who are not believers laugh at that. But it's important that as believers that we affirm that truth, that yes, if we're the sheep of God, we hear his voice. We really do. So I love that Judge Duncan, even before he was a judge, was talking about hearing the voice of God. And again, here's the quote. "It was the Lord speaking to me saying, 'You think you have it hard. Get a taste, a tiny little bit of what my son endured to save you. Do pray for us, and most importantly, that the Lord's purposes would be worked out in this litigation.'" In other words, Judge Duncan in 2012 was talking about the difficulty really in culture wars of standing for true principles. And he said he was hearing the voice of the Lord tell him, and I'm paraphrasing now, but saying, hey, Kyle, you think you have it difficult? Think about my son, Jesus, who went to the cross to die for you and how difficult he had it. That's the point that Kyle Duncan was making back in 2012. There's also a quote, again, talking about his worldview, talking about where he was talking about James Madison, and Kyle Duncan said, "Madison's point still holds. Men are not angels, so they need government. and they need separation of powers. And that's why Justice Scalia was right. Great. It's talking about the nature of man, the sinful nature of man is the point. And it's the reason that we've separated power and created checks and balances, because we don't believe that a king was the best way to go. Of course, that's where we came from. And here in the United States, when we formed a new government, we didn't want to have a king, because we understood when you give all power of legislative power, executive power, judicial power to one person unchecked, it doesn't go well, because the nature of man is sinful. Left alone, he tends to drift in the wrong direction rather than the right direction. And that was the point that Kyle Duncan was making. On the topic of the Second Amendment, back in 2018, Judge Duncan voted against upholding a federal law that threatened Second Amendment rights. And this was in the case of Mance versus Sessions. Judge Duncan joined the dissent of Judge Ho, Elrod, and Willett, arguing against the majority's refusal to rehear the case en banc when a Fifth Circuit panel upheld a federal law requiring firearms dealers to only sell guns to in-state residents. Really good opinion. On another topic of the administrative state, we've got a little bit more here to cover. We're close to wrapping up, but I want you to hear all of this. On the topic of the administrative state and of the danger of it, when discussing the major questions doctrine, Judge Duncan explained that, quote, an administrative agency is a creature of law. And because the administrative agency is not directly accountable to the people, in order to preserve some accountability, we have to find a legal mandate for it. In other words, he was addressing the problem with executive agencies that think they can just make rules and change the meaning of law when they're not accountable to the people through election, or even to the president. The president's elected and he wants the administrative agencies to do things the way he thinks it ought to be because he's elected. Judge Duncan was pointing out that those administrative agencies have to be accountable somewhere, through the law or through their boss, the president. And finally, on the topic of government overreach, there are two cases from the last 5 or 6 years that are very important dealing with COVID. Pardon me, one dealing with voter ID laws and the second dealing with COVID. But in 2020, of course, running up to the election, there were a lot of problems with laws not being followed with elections and ballots. It was a massive problem. And Judge Duncan supported voter ID laws and upheld election integrity during COVID-19. This is when he was a judge in 2020. He wrote the majority opinion in the Texas League of the United Latin American Citizens versus Hughes, and it was upholding Texas's absentee voting laws. So Judge Duncan's opinion explained, quote, first, and then there was a lower court opinion that went the wrong way. Judge Duncan was disagreeing with that, and he wrote, first, the district court vastly overstated the character and magnitude of the burden allegedly placed on voting rights by the October 1 proclamation. Indeed, one strains to see how it burdens voting at all. He further stated, states have critically important interests in the orderly administration of elections and in vigilantly reducing opportunities for voter fraud. We had a ton of that in 2020. A lot of judges caved on that issue. I remember I was working on cases and very involved at that time. It was a difficult time for our nation, and a lot of judges were running scared. Judge Duncan didn't run scared. He did the right thing in the Hughes case, and so God bless him for that. It's evidence of courage, which is one of the things we look for, because it shows that they're willing to suffer for a difficult position, and that's what we need on the Supreme Court. So one of the things that we like about Judge Duncan's opinion in the Hughes case is that it was a courageous opinion when it wasn't easy to do that, and that's one of the things we look for, not just to find evidences of people taking the right positions when it's easy. It's better to find instances when they've taken the right position when it was difficult or when they suffered for it, because it shows courage. And it's a much better indicator that they're going to do the right thing every time, not just when it's easy at the Supreme Court, right? Another example of that was in 2021. He supported bodily autonomy and disfavored governmental overreach regarding the COVID vaccine. he signed on to an order written by Judge Engelhardt to block the implementation of OSHA's emergency temporary standard for COVID-19, so-called vaccination. The order by Judge Engelhardt states, "It is clear that a denial of the petitioner's proposed stay would do them irreparable harm. For one, the mandate threatens to substantially burden the liberty interests of reluctant individual recipients put to a choice between their jobs and their jabs." Duncan also wrote in his concurrence in that case, "Whether Congress could enact such a sweeping mandate under its interstate commerce power would pose a hard question. Whether OSHA can do so does not." Excellent point by Judge Duncan. And then also on the Fifth Circuit panel, he wrote that accepting the vaccine would directly burden their respective faiths by forcing them to inject an unremovable substance at odds with their most profound convictions. And ultimately, Judge Duncan found that, quote, "These circumstances of imposing the COVID jab impose a substantial burden on plaintiffs," speaking there about religious freedom, religious rights of people who didn't want to take the so-called vaccine. So that's just some of the research that we have on Judge Duncan. Again, you can find the research on the jagf.org website, and I encourage you to do that and form your own opinion. Be engaged with us on judicial nominations and researching the prospects that are out there. It's important as we look forward to a possible vacancy in the coming months. And so we all need to be prepared for that and not be caught off guard. Thank you for taking some time investing this, and we'll have future videos on other prospects, both green listers and red listers. And so God bless you. Thanks for your time.